But thanks so much, Jen. We're glad you're all here with us. So today we've got some fabulous folks joining us to speak. We have attorney Carol Wessels. She's been practicing elder and disability law since 1991 and is the owner of Wessels and I always screw up how to say your partner's name.
Liebau, like take a bow.
Liebau LLC in Mequon. Thank you, Carol. I've known Carol for quite a few years through her advocacy work at the Alzheimer's Association. So I was really excited when she said, yes, I want to give this presentation today. The most critical career shaping experience for Carol was being a caregiver for her parents. She now spends her time as a warrior in the fight to end Alzheimer's disease. You'll see also she's got her purple on and her yellow flower. I think that's yellow, isn't it? Your pin?
It's an orange one.
Oh, it's an orange. It's an advocacy one. And she is on the board of directors for the Alzheimer's Association Wisconsin chapter. Then we have Molly Schroeder joining us. She is a licensed certified social worker. Molly currently works as the Community Dementia Programs Manager for the Wisconsin Alzheimer's Institute. And I've known Molly for many years, back when she was a case manager at one of the local coalitions. Thanks for joining us here today, Molly. And then we have Dr. Nathaniel Chin. He is an assistant professor in the UW Department of Medicine and treats patients at UW Health memory clinics and collaborates with many Alzheimer's disease researchers on campus and oversees the clinical care provided to Alzheimer's disease research participants, and also lost his father to Alzheimer's disease. So we have a great group of people here with us today. We'll go ahead and turn it over to you, Carol.
Thank you. And just so you know, I'm playing with how I am supposed to be doing the slideshow because I'm not particularly good at it. So just a second here. Let me make sure I'm getting to the right place that we need to be. There we go. Oops. Okay, so the presentation we're going to have today has to do with an introduction to legal issues facing people with Alzheimer's. And you know, the time is so overwhelming when you're going through the medical process of, you know, what's going on. You know, I'm not remembering things the way that I normally do, or I'm concerned, and you go and you get an evaluation, and then all of a sudden there it is. You know, you've got a diagnosis of mild cognitive impairment. And if you're a caregiver, partner, or a spouse, you're absorbing all of that along with the individual who's been diagnosed. So it's a lot to think about. One of the most important things for you to start thinking about sooner rather than later are some of these legal issues we're going to be talking about today. So I like to start with a little bit of a checkup and sort of figure out where we are right now, where some of you are right now. I'll give a full disclosure that, you know, I'm used to giving these talks in person so I can see people's reactions and I can see body language to understand if you're following me or not. And I'm not good at that yet on Zoom. So, you know, Bonnie's watching to see if people have questions. I'm going to be looking in the chat for questions. But simply, if there's something you really need me to clear up, please make sure that you get Bonnie's attention or that you put it in the chat. Is everybody comfortable using the chat? If you haven't, you can kind of give it a try because it's really easy, and no criticisms on typos because I do typos all the time. So, all right. So Bonnie, do we have the poll that's available?
We sure do.
Let's take that poll to see. Let's get a gauge of where we are to start with. When we talk about a legal checkup, we want to know exactly where you're at right now. And now you don't have to tell me publicly, and the poll results are going to be anonymous. But if you want to just answer the question about, have you completed your healthcare power of attorney? Wow, everybody's voting. This is very good. We're getting our result. We're almost there. I'm going to give another 5 seconds and then we'll end the poll. Okay. So, wow, we've got some really, really good results here. 63% of you have, and you can see the poll results if you look in your options on the Zoom, in your Zoom options, you'll be able to see the poll results. So 63% said yes, and it's up to date. That is fantastic. 20% haven't done it, and a fair amount of you have started. So that's really, really a good start. And then we have a few of you that did it, but it was years ago. So I think these are really good results, actually. I'm really impressed by the amount of people that have actually got that done. And it's one of the things we'll be talking about today, and some helpful information even for you folks who have that done yet. All right. Do we have another question, Bonnie?
Yep, here it comes.
Okay. So have you filled out and submitted healthcare Hipaa releases? So just a little bit of explanation, a Hipaa release would allow someone else to get information about your healthcare from your doctors. So how many people have done that? And if you don't even know what a Hipaa release is, we'll get into that a little bit more too. It's really important. So right now the polls are coming in, and I'll end it in a minute or two, or in a second or two. Yeah, so we've got a majority of people have not completed Hipaa releases. So that is something that we'll make sure to talk about. And because having a healthcare power of attorney is one thing, but making sure that the people you care about and want to share information with actually have a legal right to get information is another thing. So that's great. We will, stop share results. Okay. All right. So that's the second question. What's our next question, Bonnie? Financial powers of attorney. Have you completed those? We're getting some responses in. Good job. Lots of people have them done. We're getting there. I'll give it another 5 seconds. I'll give it till 30 seconds and then we'll end it. Okay, wow. So a bunch of people have already, half of us have already finished our powers of attorney documents. Others say they've got them, but they're pretty old. And less than half have said no. So, I think that's a really, really good result. Really, really good result. And so we'll make sure we touch on financial powers of attorney also. So many of you who have answered no may not actually even know why that's important. And that's one of the things we're going to cover today. So let's go with the last question. Do you have a will or trust? I'm very excited watching these polls come in because I can see it right on my screen. It's very exciting. Ooh, people are answering like crazy. 94% have voted, so I'm going to cut that off pretty soon, I think. I think we got, all right, so we've got over half of the people have a will or trust. A third, so 2/3 have a will or trust, and 1/3 do not have a will or trust. That's something that we're also going to talk about today, but here's what I'm going to tell you. In my world, working with families who have Alzheimer's and dementia, the will and the trust is actually the least important of the documents we've just asked you about. So if you're only picking one thing that you're going to be doing as far as a document, you got to get that healthcare power of attorney in place. So we will be talking about that, but this is really good. So a lot of you have really, really gone into looking at your planning and getting that done. That's great. Maybe you just want to sign off for the first half of the presentation. I'm just joking. And then come back in when we're talking about long-term care. All right. Okay, so I'm going to pull up my screen again. Okay, so hang on here. So we did our legal health checkup. Now, I like to ask when we have a smaller group, whoops. I'm going to apologize right now because I can see that I'm going to have problems making my slideshow work. There we go. There we go. I'm looking in behind me because I have a screen. So if that looks weird, it's because I have a screen behind me that tells me if I'm on the right slide. So anything on your mind, you want to put it in the chat and we'll do our best to get to it during the presentation.
So Carol, we just have one quick question that came in. Can you discuss whether a trust is better than a will?
I do see that question, and that is a question that we'll get to. We got about 3 to 4 slides before we get to trusts and wills, and we'll talk about that when we get there. That's a good question. All right, so we've got the polls that have already told us some of these things, and I'm really excited that a lot of you have a lot of your planning in place already. But you know, for those of you that do have your planning in place already, if you look at the issues on the sort of towards the bottom of the slide. So for those of you that have powers of attorney, are the agents that are on those documents the agents that you want to continue to act? Because if they're not, now's the time to update that. Have you included powers that you need to put into those documents? Have you thought through your preferences and desires? And is there any update that needs to be made? Another thing that's really important to talk about is if you are the care partner for a person living with Alzheimer's and you've got that person as your primary agent, now you want to make a decision. Oftentimes people with mild cognitive impairment can still be very involved as decision makers for another person. At the same time, due to the progression of the disease, there is going to come a point where that's not going to work so well anymore. So if your, for example, spouse with MCI is your primary agent, you may want to make sure that either you have 1 or 2 alternate agents, or that you maybe are thinking it's time to say, I'm going to put somebody else as my primary agent. And I can talk about that when we get to that part. But then another thing to be thinking through too has to do with any insurance that you have. So we'll talk about that as well. So first thing we're going to talk about is a healthcare power of attorney. And I put this first because this, in my opinion, my humble opinion, which I'm a lawyer, so there's nothing humble about me, but in my opinion, the healthcare power of attorney is the critical document that you need to have in place right now. I have a lot of clients that make an initial call about, we need to get a will in place, or we need to, you know, we need to take care of our wills. My husband's just been diagnosed with dementia. And to me, when I start to have that conversation with them, I want to stress how important the powers of attorney are, even more important than, in my opinion, than wills or trusts, because the powers of attorney have to do with who makes decisions for you while you're still alive. The trust or the will really have to do with what happens to your property after you're deceased. So I like to focus on, when I'm working with my, I call them purple canoe clients, because if you're a care partner for someone with dementia, or if you've been diagnosed with dementia, it's kind of like we're all in a big purple canoe paddling together. So with my purple canoe clients, I really want to make sure that we're getting those powers of attorney in place, because those are the critical things for right now. So the healthcare power of attorney is the most important document. And that is a document that appoints agents who are going to be able to make decisions for you about your health care. Now, a lot of people use the word living will to talk about what's really a healthcare power of attorney. And a healthcare power of attorney is a kind of what we call advance directive, and so is a living will. An advance directive means in advance of something happening, you are making directions about what you want or what you would want in the situation that we're anticipating. So, so the advance directives that relate to your health are a power of attorney for healthcare, a living will, potentially a do not resuscitate order, though that's also a type of advanced directive. The healthcare power of attorney is the one that really talks about the broadest scope of decision-making. So a healthcare power of attorney involves naming someone who is your agent, that's the person that you trust and the person that you care about to make decisions. Naming that person as your agent and maybe a couple of alternates, because we can't see the future, right? We want to say, well, if my spouse can't do it, I want to make sure there's somebody else that's in place. Those are the people that are your agents, and they'll be making decisions when they use their authority under the healthcare power of attorney. But it also involves making instructions on what decisions those agents can and cannot make for you. So let's talk about, I'm going to get to the next slide. By the way, there is a state power of attorney for healthcare form that's available. It's a very good form if you need to do something very quickly and get that filled out. Make sure that you have to have it properly witnessed, but there is a state form that's available, and it's a very good healthcare power of attorney form. The power of attorney for healthcare by default goes into effect when two physicians or a combination of other medical professionals sign a certification saying that, and when I say you, I'm talking about the person who's signed the document, are no longer able to make healthcare decisions for yourself. And when that goes into effect, when that certification is obtained, then the agent has legal authority to make decisions for what's called the principal, the person who signed the document. What's important to remember, and is often lost in the dialogue, especially relating to Alzheimer's, is that even when a healthcare power of attorney is what's called activated, so the physicians or other medical professionals have signed that certification, the individual who's the subject of this document, so if I'm the person who signed the document, I never lose the ability to make my own decisions. We've only added in another person who can make decisions. And when I can make decisions as the person who's done the document, I'm supposed to be making the decisions. So when a document's activated, it means that the person is not able to receive and evaluate information such that they can't make their healthcare decisions. That doesn't mean they can't participate in their care or they can't make some decisions. So it's really important to remember when that power of attorney for healthcare is activated, the person who's the subject of that document doesn't lose their rights. They still have their rights to make their own decisions. When we're talking about the structure of the document, though, let me get to the next slide. There are certain things in that document, and particularly if you're using the state form without somebody who's counseling you on this and sort of walking through. I mean, if nothing else, if you don't get to a lawyer to talk these things through, with a healthcare power of attorney, talk it through with a social worker or a counselor or somebody who can help you understand these decisions that are being made. With the healthcare power of attorney, I think there's a number of qualified individuals who can counsel you on what some of these things mean. Of course, I'd rather that you talk to an attorney who can help you with these things. At the same time, with the healthcare power of attorney, there's a lot of people that can help you with these documents. So the healthcare power of attorney in Wisconsin requires certain things to be specifically listed in the document. And on the state form, they're listed right there. On documents that we draft for people, we put the language in the document. So however it happens, these certain addressed. So one of them is whether, and probably the most important one for us to be talking about today, is whether or not your agent can admit you to a nursing home for a long-term stay. And there are two answers to that, yes or no. If you answer yes, first of all, if you don't answer it at all, your agent is still going to be able to have the ability to admit you to a skilled nursing facility or to a community-based residential facility with more than 16 beds for a short-term stay. So think of the situation where maybe you are hospitalized and you need to be in rehabilitation in the rehabilitation side of a nursing facility. Your agent can do that regardless of what you answer on this question. Okay, this question is about long-term placement in one of these facilities. And so the two facilities that are involved are a skilled nursing facility, which most of us think about as a nursing home. And the other is a community-based residential facility. So there are different levels of assisted living care, and a community-based residential facility is one of those levels of care. And it's one of the higher levels of care. It's like right under the care that's provided in a nursing home. So the state legislature made a decision that if we're going to admit somebody to a place that has that higher level of care, most of the places that you think about as memory care units are CBRFs of this level. So if we're going to make a long-term placement there, we need to know that the principal in this document specifically said that it was okay. So that's where you have the decision of checking yes or no on those boxes. And the most important thing I can tell you today is that checking no doesn't mean you're not going to end up in a nursing home. So people feel very strongly that, many people want to stay in their home as long as possible. That's definitely a very valid sentiment and a goal to be achieved. At the same time, saying, well, I want to be in my home, so I'm not going to give my agent that authority to admit me to a nursing home. It just doesn't mean that you're not going to go into a nursing home if that's necessary. It's just a process of how you're going to get there. Because if you medically need to be in a nursing home, you're going to be in a nursing home. And that's just a reality of life. So the question is, how do you get there? If you've checked yes on that box, then your agent does have the authority to admit you there. But you can make specific directions to your agent to say, hey, I want you to try all possibility of keeping me in my home before you admit me to a nursing home. I want you to spend every single penny I have on home care before you put me into a nursing home. And those are directions that your agent needs to follow. But at the end, if you checked no and you need to be put in a nursing home, the process that's going to have to be followed is a guardianship and a protective placement. And let me talk to you just a little bit about that. That's why I keep telling people that the healthcare power of attorney is the most important document, because first of all, if you don't have a healthcare power of attorney in place and a decision needs to be made, or second of all, if you've checked no on that skilled nursing box, then guardianship is the result. And what guardianship involves is that someone, usually one of your family members, has to file a petition in court to have you declared by a court of law to be legally incompetent. And they have to present medical evidence and medical evaluation. And all of that is reviewed in a court. And so now the decision-making is not in your agent's hands or your loved one's hands or even your own hands anymore. It's in the hands of a judge that you've probably never met and don't even know. And a guardian ad litem will be appointed who is going to meet with you, or is going to meet with the person who's asking to be appointed guardian. And they're going to make the judgment on whether that's a good decision or not a good decision to appoint someone as guardian. So the decision-making is out of your hands when it's in the hands of a court. And while we do that when we need to, it's an absolutely necessary process in some cases. If there are steps that you can take to avoid that, you really want to do that. So that's why I don't mince words when I'm talking with my clients. I say, I advise you to check the yes box on that skilled nursing facility question. That's my legal advice to you. And I'm not any of your lawyer, but if you were sitting in front of me in my desk, I would be telling you the same thing. And the reason for that is that your agent's job is to act in substituted judgment, which means your agent's job is to do what you would want. So checking that box can allow you to give instruction to your agent as well, to tell them that you want to remain at home, that you want them to spend all of your money on home care if that's what it takes to keep you at home, that you don't want to be in a nursing home unless it's a last resort, if that's your preference. And frankly, your agent needs to follow your direction, not make their own decisions about what they think is best or what they would do in that situation, but it's about doing what you would want. So the idea of the healthcare directive, it's substituted judgment. That means my agent does what I would want. And so, for example, I worked with a family, and it was kind of an awful situation, actually, for a little while, but we got it all resolved, where they knew that their mother was sort of on a pureed foods diet, and their mother loved food. And so they were being very adamant with the healthcare providers that they wanted to get her off that diet as soon as possible so that she could continue to enjoy her pureed food. And that if there was a choice between, honestly, these are the decisions that come up. Maybe she's going to be eating the soft foods she likes, and there's a higher risk that she's going to choke, versus eating the pureed foods that she doesn't have any interest in. Well, we want her to have the soft foods because we know that's what she would like. She would like to eat that food. For me, it's a simpler decision. If it's a question of giving me a salad or a piece of chocolate cake, I'm going to take the chocolate cake. That's substituted judgment. My agent might look at me and say, Carol, you need to lose a few pounds. I should probably have them serve you the salad. That's best interests, right? So best interest is a salad. Substituted judgment is chocolate cake. That's the only way I can explain it in a kind of an understandable term. But that's the process that's involved. So giving your agent broad authority and then giving them good direction is the best way to fill out this document and the best way to do the healthcare power of attorney, if that's where we're going. Okay, so now I'm going to switch to the next slide. There we go. Now, the thing about a healthcare directive is that it's your decisions and your choices. So you can put anything in there that you want. There are, in the standard form, there is a set of lines for special provisions. My form is a lot longer than that because you can take up more space, but even if you're filling out the standard form, you can attach language that's important to you. So when I'm talking to people with dementia, then I'm asking them to consider whether or not they want to add some specific paragraphs related to their dementia. Like I asked them to think through on that whole assisted living setting or the whole if they can't live in their home anymore, what's important to them as far as a new residence, like an assisted living facility. For me, it would be a place where I can have a dog. My dog's here in the office with me today. That would be a very important thing to me. And if you want to list special provisions, you can. You can also list, more detailed provisions about your preferences for end of life care. And you can put that in your healthcare power of attorney. But one of the things that I bring up, and I have some sample paragraphs in the slide so that you can take a look at them. They really specifically have to do with the idea of, situations involving dementia. I have to be really blunt with you that one of the biggest problems we run into in healthcare powers of attorney has to do with the fact that a person with dementia may not be fully aware of the state of their abilities and inabilities. And so a person with dementia at some point in their journey may not recognize that they need the care that objectively they need. And so my mom, for example, is a perfect example of that, because she was, after my dad died, she was, my mom and my dad came to live with me very suddenly. My little bit of my backstory. At the time I had been an elder law attorney for many, many years. I knew that my mom had dementia. My mom and dad lived about 45 minutes away from me. And, dad was dad. He's a World War II veteran. He's going to do, what he's going to do. He was a good husband and he was taking care of my mom. And they came to my house for Thanksgiving. We had a nice dinner. You know, mom was repeating things. We kind of understood that. And then the next day I got a call from my dad saying, I need you to come and pick me up. And he described a medical condition that was going on. I need to go to the emergency room. Dad, I'm 45 minutes away. Why don't you call an ambulance? No, I'll just wait. You come and pick me up. And so I took Dad to the emergency room, and it turned out that he had bladder cancer in the past. That was a treatable condition, but because he was caring for my mom, he stopped getting treatment and stopped taking care of himself. And so the cancer had progressed a lot farther than he thought. And so that weekend, my parents moved in with me, and that began my journey as a caregiver. So my dad died about 6 months after that, and I had mom. So where was I with this situation? So then it became very clear as the family member that we had no idea how bad things had gotten with my mom. But my mom was always a very verbal and articulate woman. So she had been masking for a long time, and we had been believing it because we were just talking to her on the phone a lot of the times. So anyway, I started looking for assisted living care for her because I knew that in the future that was going to be necessary. But when I had the discussion with her about that, she said, why would I need to move anywhere? Now, remember, she's living in my house. This is my house. I do all the cooking and cleaning around here. I'm perfectly capable of taking care of myself. And that was the discussion. So she wasn't at that stage where either she was aware of her limitations or she had progressed to the point that it didn't matter anymore. I had a very difficult time when it came to time to admit her. And this isn't about my story, but it's about giving you an example of why some of these dementia paragraphs might be helpful. Because if a person who's at the beginning of the disease can understand and be educated that at some point they may not be aware of their limitations, they may want to include language in the healthcare power of attorney that recognizes that and says, there may come a time when I'm not aware of my limitations. And if my doctor has diagnosed me with moderate stage of dementia, I want you to really listen to my agent and take guidance from my agent on the decision making. So that's the point of some of these paragraphs that I've indicated. So hopefully you can take a look at those. And we will, so there's one of them. Talking about the fact that I know things might get worse as far as my ability to understand things. That's plain language. Here's another one. If my treating physician has indicated that dementia has progressed past the early stage, this is what I was talking about. I want to make sure that you understand that what I say is to be considered, but my agent makes the final decisions. And then what's most important on the healthcare power of attorney, you'll notice that I spend probably an inordinate amount of time on this document, but what's most important is to talk with your agents because of the fact that they are exercising substituted judgment. That means they're standing in your shoes to make those decisions based on your preferences. They need to know what those preferences are. And it can be overwhelming for people to get into these discussions. It can be kind of daunting and people may say, I'm not ready. But the theme of what I want to go through today, I mean, you guys are courageous. Those of you who have gone through the diagnosis and are watching this, or your care partners, you're very courageous people. You have gone really far to get to where you are right now. You've taken steps. And this is one of those steps that you also need to take. Because if you put it off for too long, I'm not ready is going to turn into I'm not able. And when we get to I'm not able, then people haven't heard from you as far as your decisions and your preferences. And if we get to I'm not able and the healthcare power of attorney is not in place, then we are facing that process of guardianship, which is a very traumatic process, even when it goes very well. So I just want to make sure that you start having those discussions with your agents and you get this document done. The next most important document, and I'm seeing the questions that are coming up about talking about wills and trusts and things like that. But the next most important document is a financial power of attorney, because that also is something where if it's not in place, then if somebody needs to make financial or legal decisions for you, the only alternative then is a guardianship of what's called a guardianship of the estate. So there's two different kinds of guardianship. Guardianship of the person allows someone to make healthcare decisions for you. Guardianship of the estate allows someone to handle your finances. So the financial power of attorney allows someone that you choose to act as your agent and handle your financial affairs. Now, there is a state form for this, but I am going to tell you that while it's better than nothing, the state form does not educate people very well at all about what additional powers they could add that are really important in the long-term care planning side of things. And so when I have clients that come to me and they have a financial power of attorney that is one of the state forms, we're very limited in what we can do to help people maximize the amount of assets that they can save for long-term care planning or transfer assets between spouses. So that is better than nothing in terms of if you include the authority in that state form that allows your agent to pay your bills and sell real estate, they'll be able to do that. But unless you really investigate the additional powers and you include those with that state form, we may get to a point where our options are limited in long-term care planning. So my personal opinion as an attorney is that that's not the best option for that document. Using the state form is better than nothing, but you can do much better if you actually talk to an attorney who's going to be able to walk through these things with you and put the powers in there that should be in there to maximize the ability to do planning for long-term care. If you do have a power of attorney in place already, what's really important while you can is to get that document recorded with financial institutions, get the person that you've named added onto your account as an agent, not as a joint owner, but as an agent, so that while you have capacity to have discussions with your bank about these things, that you're making sure that those are in place. Because the biggest problem that we run into as elder law attorneys is not getting the healthcare power of attorney recognized by a healthcare provider. By and large, if you've got that document in place, that goes very smoothly with healthcare providers, but financial institutions are a different thing. And they're constantly making very arbitrary policies and rules that make it difficult for your agent to do their job. So the sooner you can get your agent added as an agent on your accounts while you're still able to be there and answer the bank if they have questions, the better. If you are a care partner or family member of someone with dementia who has this financial power of attorney, and maybe they're past the ability to participate in getting you added, do this sooner rather than later. Present that document to the financial institutions involved. What you might also find too is that a financial institution has its own power of attorney that it wants you to fill out. So that's important to do as well. If you are, mild cognitive impairment and you have, let's say, a Schwab account or Fidelity or Stifel, one of those investment brokerage accounts, you may want to look and see what their standard power of attorney requires and get that on file as well. So that's financial power of attorney. All right, what's next?
Carol?
Yes.
We have a quick question here that now might be an appropriate time to answer. One of the questions is an attorney in fact the same as an agent?
That's a good question, and the answer is yes. So the attorney in fact is not your lawyer. The attorney in fact is another name for agent. Another name for that is fiduciary. That's a big, complicated legal term. But an attorney in fact does not have to be an attorney. It's the person that you've named to be your agent. So yes, that's a good question. Hope that answers that one. All right, now let's talk about something very important as far as this legal standard to get these documents executed. The standard for the documents, so in other words, if we're talking about somebody with mild cognitive impairment, certainly somebody in the end stages of Alzheimer's, like my mom at the end in the nursing home when she was non-responsive and not eating, she couldn't sign a new power of attorney, okay? She couldn't do that if it was necessary. That's clear, because she no longer had capacity to do a power of attorney at that point. And capacity is the idea that you have to understand the legal document you're signing, and you have to be able to make some rational choices about who your agents are going to be. And you have to be able to understand the directions that you're giving them in the document. So one of the things that we talk about is the difference between activating a healthcare power of attorney and this. And I see a really good question that came up in the chat that I'm going to deal with in a second. Activating the healthcare power of attorney versus executing a healthcare power of attorney. So executing a power of attorney requires a fairly low level of capacity. In other words, even a person sometimes, and everybody is different, but maybe in the mid stages of dementia is going to have enough capacity to understand and execute a power of attorney for finances or healthcare. Again, it's a case-by-case basis, but getting the document, let's say, for example, the healthcare power of attorney activated means that the healthcare professionals has stated that you can't receive and evaluate information to the extent that you can't make your healthcare decisions. And the way that I explain the standard to activate versus the standard to execute capacity is this. So my power of attorney could be activated because due to my dementia, my mom was also, I talk about my mom a lot. My mom was a cancer survivor and she had a very rare kind of cancer. This was before her dementia. It may have contributed to it, but I'm not a doctor. So before she had dementia, she survived cancer and dementia. She died from dementia. So she had a very rare kind of cancer. And there were 3 different kinds of this cancer. And for us to understand this diagnosis, we had to know there's this kind of this cancer, and then there's this kind of this cancer, and there's this kind of this cancer. This kind of this cancer is very rapidly progressing cancer. This kind of cancer you could live with maybe for your whole life. And she had to understand where she was in that spectrum and be able to make decisions about what the treatment options were. That's holding a lot of information all at once and evaluating it and making a decision about her plan of care. Ultimately, we took her to Washington, D.C. And like I said, she survived this rare kind of cancer because she had special treatment out there. But she made those decisions and she had the capacity to do it because she was able to evaluate her options. Now, maybe a person with dementia wouldn't have that capacity to recognize that different types of care that are available and evaluate the options. But the standard to execute a healthcare power of attorney is to understand the power that you're giving to someone. So to say, well, I'm gonna, by signing this document, I'm giving someone the ability to decide if I need to go to a doctor, to decide if I were to need surgery, to make decisions about medication, to make decision if I needed to be in a nursing home, although I really don't want to be there. And that's what I'm letting my agent do. And then the second part of that decision is, who is that person that I trust? Who's going to make that decision for me? Well, I really trust my daughter, Carol. So I'm going to name her as my agent. I think she would do a good job. Can you see the difference in capacity versus evaluating cancer and treatment options versus understanding the general powers and the person who can exercise those powers for you? So that standard for capacity is pretty low. And even in cases where we have an activated healthcare power of attorney, and again, it's a case-by-case basis, there may be a person who can still update their estate planning and still do, do things like that. But we don't want to wait any longer than we have to. So let's not get to the point where we're even asking the question. Let's get it done ahead of time. And so the really good question that came up in the chat, and they're all good questions, right? But the question that caught my attention was, if your agent is your spouse, do we still need to have me listed as agent? Thank you for raising that, because it's one of the most common things that people have a misconception about. So maybe those of you that haven't done your healthcare power of attorney, or some of you are thinking, well, I'm married, my spouse can make decisions for me, so why do I have to put this in place? Under the law, no one can make decisions for you once you're an adult, with very few limitations. There's some little emergency exceptions to that. But even your spouse cannot make medical decisions for you unless you have named them as your agent. So even married couples need to have these powers of attorney in place. And it's the same thing, oh, all of our accounts are joint. Well, that means your agent, your spouse is an owner on the account, but it doesn't mean they have legal authority to do things for you. So it's really important, even if you're, a spouse or even a parent or a daughter, any person who's related to you by blood, love, marriage, they don't have legal ability to make decisions for you unless A, you give them that authority by doing the power of attorney, or B, they're appointed by a court as your guardian. And we also always want to go with A if we have that option. So just remember that as your answer to that question. All right. So now I'm going to go to the next slide. All right, and we've talked about this. This is what happens, sad puppy. If you haven't done those documents, then we may need a guardianship, and no one's going to be happy about that. At the same time, I will point out that I have clients, and again, this is a personal decision, that have knowingly made the decision to say no on that nursing facility question, because they say, you know what, I feel so strongly about that I do want someone to have to go to court and get a court order if they want to put me in a nursing home. That's a perfectly valid decision if that's your value. If that's the way you feel about it, just understand the consequences. But the people who are going through that process for guardianship are not happy to be doing it. It's a stressful process for everyone. So that's it on the healthcare and financial power of attorney. I'm just going to take a quick pause. Any questions that I missed or that anyone asked?
Some questions come in privately.
Oh, if no, here's another one. If no family, who do you suggest as agent on a trust? Oh, on a trust. We'll get to trust in a little bit. I'm just looking through the chat here.
We've got some that have come in privately to Bonnie and myself.
Yes.
One of the questions is, can you have more than one agent?
You mean at the same, so I'll answer that question a couple different ways. As far as having more than one agent at the same time, in other words, co-agents, you can do that on a financial power of attorney, although I don't recommend it, and it's a longer discussion. I recommend 1, 2, 3. But on a healthcare advance directive, no, you have to, the law is written so that it talks about a person being an agent. So one at a time, name 1, 2, and 3. And sometimes you have to make those choices.
Oh, this is Molly. Just wanted to share a couple of examples from cases that I've worked with in the past, helping people with their POAs, some situations that came up. And I'm glad you talked about the importance of having an agent, deciding who's the agent, and also just if they're comfortable being an agent. I think that conversation is missed a lot. I had a client who had listed her brother as her healthcare agent, unbeknownst to him. Hadn't talked to him about it at all, but had him listed for a long time. And I said, does he know that you've listed him? Have you had a conversation about this? And she had not. So it was an example again where she just assumed that their family, he would do that for her. But I encouraged her to call him, to have a conversation about it, discuss what, so forth. ultimately he did agree to it, but I said, it's really important to have those conversations. And just another reminder for everyone too, about the importance of updating your healthcare documents. I personally suggest annually. Things can change over the course of a year drastically. I had another situation where a client I worked with had an activated POA for healthcare. We had to contact the healthcare agents about a situation. I don't recall if it was placement into a CBRF or something. The healthcare agents had been assigned like decades ago. And they said, oh my gosh, we forgot we were even listed. To be honest, we can't do it. We're not in the, we're just not in the position we can make those decisions for her. We haven't seen her for years. We don't know even what her wishes are at this point. So they had to revoke their healthcare agent designation, and it had to go through the guardianship process. So when I've helped people do their annual assessments or reviews, we took that time to look at their POA documents and update them as needed.
Right. And it's a good reason to have alternate agents on your healthcare power of attorney. I recently dealt with a situation where we had a couple and the spouse had dementia, and I was working with the wife because she had been diagnosed with cancer and it progressed very rapidly. And one of the unfortunate situations was that the husband had only named his wife on his power of attorney. I mean, good thing that he had done something, but he had only named his wife. And so she died before he did, just like my dad died before my mom. And we had to go through the guardianship process for his son to be able to take over to handle his finances because he had only named his spouse. So naming alternates is a really good idea because none of us has a crystal ball in the future. And it is, again, something to think about, when you're a care partner for someone who's going through this process of being diagnosed with dementia, sometimes the world is revolving around that person. At the same time, something else could happen to you. And we need to have those protections in place to deal with that possibility, unfortunately. So good points, Molly, about those situations. Now, there was a good message in the chat from Frances. So she says she has the power of attorney, but does she need to call banking accounts to list as an agent if she's listed as the spouse? So that is a good point of clarification. Thank you. If you are a joint account holder, you don't also need to be the agent on that account because you already own the money in that account. But there is so much more to being power of attorney than just the bank account. So for example, if any of you has individual accounts, you should list your agent on those accounts. And make sure you're going through any of those other things. On a joint ownership account, if we're talking the spouse, no, you don't have to be listed as agent on something that you already own. So that is a good point of clarifications, that you don't have to do that. All right. So
we've got while we're in this agent section, we've got a question from somebody who is, I just want to find it here. She's a single, he or she is a single person, and they're concerned about how do we go about determining agents or receiving help with determining agents if there are not, spouses or children, those types of things. Any suggestions?
Right, I did see that come up in the chat, and it was referenced to trust. So I was going to talk about it later, but it definitely applies also to powers of attorney. And that's a really big issue that we're dealing with now in the legal community is, what if you don't have family? Or what if you don't want to name your family member, or your family member is so far away? I would say, first of all, if if it's a family member who's very far away, if you would otherwise trust them, having them on the document is better than nothing. If you have no family, for trust purposes, we have financial institutions that if you have enough money, will have a corporate trustee that can, a corporate trust services. So if we're talking about trusts, we can have a professional trustee or a financial institution manage those funds if there's enough money in there. But as far as agents for healthcare or agents for finances, it is very difficult. You may want to think about a trusted friend. It's, there are, unfortunately, the end result, if there aren't people that you can think of, are that if you do need a guardian, you may end up with somebody who is a volunteer or a corporate guardian who is never going to have known you. So if you can think of anybody that you could trust, and for healthcare power of attorney, since they have to be activated, it might be sort of an easier decision. With a financial power of attorney, if you're trying to pick someone, that might be a case where you change the standard on the financial power of attorney to say this only goes into normally financial powers of attorney, we like them to go into effect without doctor having to certify anything. And it's a longer discussion than we can have today as to why. But you might want to have that power of attorney only go into effect if you're incapacitated, because then this person that you're choosing is only going to have authority if you're incapacitated. And yeah, the point was corporate guardians they cost money. So anybody that you have to pay to do the job is going to charge. So that's another thing. And so I would just say, as a single individual, if you can cultivate friends or people, maybe you can come to a relationship with a friend of yours that I'll be yours and you be mine if we need to. It may end up being better than nothing. So it is a difficult decision, and I don't have a great answer for it. I think it may be one of those services that pops up a little bit more as our generation ages and we're spread apart more. So moving on a little bit though, just quickly, it's also a good time when you have the diagnosis that if you have insurance policies, so short-term or long-term disability or long-term care policies, now is the time to sort of really read through those and get familiarized with what the standards are to start getting what you've paid for. So what do I need to show to get that long-term care policy to start paying out? And is that a good idea to do that now? Or will this policy pay for care in my home? Or is it only limited to care in a nursing home? So it's the time to really start looking at those. And if you have questions, the Office of the Commissioner of Insurance has a long-term care insurance section, and they do a really good job of free counseling. So you may want to reach out to them. Again, you may want to reach out to an attorney. That's up to you. But those are things that we can help with. Now we're talking about the will and the trust. So if you don't have one of these in place, it is important to be thinking about it now. If you die without a will, there are laws that talk about where your property goes when you die. So it doesn't mean that nothing's going to happen if you die without a will. It just means that things are going to happen the way the law says that they're going to happen. So if you're married, it goes to your spouse, unless you're like me and you have children from a previous marriage. So if I would die without a will, then my property would go half to my spouse and half to my son, Ken, because he's my son from a previous marriage. If I had 4 kids from 4 different marriages, it would be divided in fractions like that. So there are laws that say what happens to your property, but if you want to be in control, you need to do either a will or a trust. And that is something that you should, in terms of the pros and cons of which one works better. And that was one of the questions. That is an individual decision. And that is something I cannot say that a revocable trust is always going to be better, or that a will is always going to be better. I probably wouldn't say that anyway. But it's an individual situation that depends on your circumstance. I will explain the difference though. A revocable trust is a document that gets set up. And if it's set up correctly, it allows for your assets to pass outside of probate to people that you've named in that trust as the beneficiary. So a trust is a written document. You sign it just like you do your other documents. But in the document, you say, here's where I want my stuff to go when I die. And the nice thing about a revocable trust is you can change that at any time with what's called an amendment. So if today I want to leave everything to Bonnie, but next month I decide I want to leave everything to Nate, I can make those changes as long as I have capacity to do that. Honestly, I would probably leave it to the Alzheimer's Association. So sorry, guys. But anyway, you can make those decisions in your trust. And then if you've set everything up correctly, the trust controls what happens to your things when you die and your money, your stuff. The key with a trust, and I want to talk to people about the idea that you're going to have a lot of companies and people out there that want to sell you a trust for a fair amount of money. The bottom line, and if you have a trust in place, this is now the time to make sure that your assets are connected to it. So just to very brief, it's a complicated situation that I really go through in person with people. But if you have a trust that you put into place, it's like having a really fancy light fixture. Okay, a chandelier, a crystal chandelier. They work so well that they're gorgeous and wonderful and beautiful, and they cost a lot of money. But if you don't connect your assets to the trust, it's like not connecting electricity to the light. It's not going to work. It's just going to be a useless piece of junk. So the key to having a trust work well to avoid probate is connecting your assets. And that's what you have to make sure you do. Otherwise, you're going to have a probate just the same as a person with a will. So then let's talk about the will. People come to my office. I want to have a will because I don't want my kids to go through probate. Well, then the will is really not the tool you want, because what people don't understand about a will is it requires a probate. A will is only valid in probate court, so it has to be admitted to court. And what a will do at that point is in the will, you say who gets your stuff after you die. You also do a very important thing, which is to name a person as your personal representative. So that's the person who can act in your behalf after you're deceased. So wills are very important things to have, but if that's all you have, then that will has to be admitted to probate courts for it to be effective. So the will is going to need a probate to be opened. And that's okay for some people. That's the way that they want it. A trust, if you do it correctly, would not require a probate. Also, what's important to understand is even with a will or a trust, accounts that have beneficiaries designated on them are going to be controlled by the beneficiary designation. So for example, on your IRA, you hopefully have if you have one, you've named beneficiaries on it. It doesn't matter what your will or your trust says. The people that are named as your beneficiaries are who are going to get that account when you die. Same with life insurance. So oftentimes when we're talking about a trust, we're changing those beneficiaries. So the trust is the beneficiary. That's how we get the property into the trust. But so beneficiary designations control regardless of what kind of estate plan you have. Will requires probate. Trust, if you do it correctly, avoids probate. Now, another thing to understand about a revocable trust, and remember this is 101, so I can't get into a lot of detail about this. A revocable trust does nothing to protect your assets if you're talking about, will I need long-term care? Does nothing. Revocable means you have control of that asset and the finances. And so for Medicaid purposes and long-term care planning purposes, all the assets in that trust are considered your assets and are available. So long-term care planning is a different kind of trust that we would need if you wanted to do it, and it has some consequences. So that's why I want to make sure that people have, you know, their beneficiary designations updated, that they're, you know, that they're doing what they can to avoid probate if that's a goal, and making sure these things are done now as opposed to, you know, being done later. If you are a spouse whose spouse is a person who's been diagnosed with MCI, you may want to do some things differently. There are trickier options, more complicated options, that instead of leaving assets to your spouse directly, would leave assets in a special kind of a trust. And that may be a good time to change those beneficiary designations so that we're protecting that spouse in case you die before them. Okay, so if you haven't done it, do it now. One of the questions that was in the chat is, do I need a lawyer for all of these things? Absolutely not. You can do all of this on your own. I don't recommend it. I'm a lawyer, and I will be brutally honest with you and tell you the cases where people did things on their own are the cases that end up being the most expensive for them if they did something wrong. So, you know, a stitch in time saves 9. You know, a penny spent on a lawyer is better than thousands of dollars spent on a lawyer later on, because you want to make sure these are done right, particularly if you have a disease that's not going to get better and there comes a point where you can't fix it. Like the individual who only had his wife as his agent. You know, if they had seen me in time, I would have strongly suggested, even before she was diagnosed with cancer, that he name a second person, because I've seen it happen. I know what happens if you only have one agent. And instead, that family had to go through a very costly guardianship. In addition to losing their mom and their dad having dementia, they had to go through this process of guardianship, and it was not a good time for the family at all. So if you talk to a lawyer, hopefully a lawyer is going to help you anticipate some of those problems, plan for them, make sure the documents are done the way you want them to do. So, I mean, nobody likes to spend money on a lawyer, me included, but it's better to make sure it's done right. So that's my 2 cents worth on, do I need a lawyer for these documents? All right, so that's it on the estate planning. Now we're going to talk, and we're going to do an overview of the long-term care programs. And I want to start by saying this is very much an overview. It's not in depth, and it's not going to be rules. It's not going to be rules that apply to an individual situation. And I want to also say that after 33 years of being a lawyer and doing elder law, I kind of understand this stuff enough to be able to help clients with it. When my mom was diagnosed with dementia and I had to go through the process myself of obtaining benefits for her and thinking these things through, it was confusing to me. So if it's confusing sometimes to an elder law attorney who's, you know, been practicing for a long time and pretty well recognized as an expert in the field, it's going to be confusing to you guys. So don't be overwhelmed if some of this stuff just doesn't click the first time or the second time or the third time or the fourth time. But hang in there, because the information can be helpful. And I'm going to go over a lot in the next 20 minutes, but it's just the tip of the iceberg. And it's enough for you to understand. Maybe my goal is that you'll know some red flags, and you'll have some like Easter eggs. So you'll have some good things that you're going to learn that you didn't know before this. And then you're going to have some things where you know, okay, I've got to be really careful about this to understand it. So you're not going to know everything, but you're going to have red flags and you're going to have Easter eggs by the end of this, I hope. All right. So long-term care is not just nursing home care. Long-term care means a person, because of their medical condition or their cognitive impairment, needs help with activities of daily living. So things like eating, dressing, bathing, money management, Those are all different types of activities of daily living. So if a person, because of either their medical condition or their cognitive impairment or a combination of two things, needs help with those things, then we're talking about long-term care. So it's not just care in a nursing home. It could be care in your own home. It could be care in an assisted living facility. So long-term care can be provided in a bunch of different ways. It's just the concept that you're needing help with activities of daily living. Some people need a lot of help. Some people only need a little bit of help, but it's still long-term care. So the programs in Wisconsin, and again, so for my friend in Ontario, what I'm talking about today applies only in Wisconsin. It doesn't apply anywhere else. I'm not licensed to practice law anywhere else. And so I only know what's going on in Wisconsin. That's confusing enough for me. So I think in Canada, you have a really good health, well, let's not go there. Anyway, different kind of healthcare system. So Wisconsin law. In Wisconsin, the programs that cover long-term care are Medicaid, which other people call Title 19 or medical assistance. Family care is another program that covers the cost of your care. And family care actually is a long-term care program. It's a Medicaid program, but it's just operated a little bit differently to focus on providing care to people in their homes and in assisted living facilities. One program that does not provide long-term care coverage is the insurance that many of you probably have, which is Medicare. So people are oftentimes really shocked about this. Let's get into this discussion. Okay, so Medicare really only covers very limited skilled nursing care. So Medicare and Medicaid are two different health insurance programs that are based in federal law. Medicare is the health insurance program that's available to everybody that has a qualification for Social Security through having worked enough or being related or married to somebody who has that qualification. So Medicare is a health insurance program that's not tied to having a limited amount of assets or income. It's really tied to your qualification for Social Security through the Social Security system. Medicaid, and I want you to think of aid being the way to understand this, is a welfare program. It is a needs-based program. So in order to qualify for Medicaid, you have to demonstrate that you have limited assets and limited income sometimes. And the Medicare and Medicaid both provide health insurance coverage, but really the amount of coverage that's provided by Medicare in the long-term care context is very small. So they're very different programs. All right, so Medicare, which is the traditional, the health insurance that many people just have by virtue of their work history, really only provides very limited skilled nursing care. And let's start with the understanding that for people with dementia, if you do need to be in a long-term care situation or in a nursing home, chances are the level of care you're getting is custodial care, because skilled care is defined very clearly as different types of medical services, skilled types of medical services. I won't get into it today, but that's what Medicare covers. And Medicare only provides that coverage if you've been admitted from a hospital. So if you've been in a hospital on an inpatient basis for 3 days or more, and then you go directly to a nursing home in most cases, and you need skilled care, then Medicare will cover up to 100 days of skilled nursing coverage. So that is not the situation that applies to most people with dementia. Most people with dementia, if we need long-term nursing home admission, like when my mom finally needed to go into a nursing home at the end of her life, she wasn't going there from a hospital. She was going there from the assisted living facility into the nursing home. So she never qualified for Medicare coverage at all. And that's most people that are having a dementia-related admission to a nursing facility are maybe coming from the home or maybe only needing custodial care. So Medicare is just really not the source of coverage that we're looking to when we're talking long-term care. One thing to remember though is in Wisconsin, if you do have that Medicare coverage and you have a skilled nursing stay that is covered by Medicare, and you have a Medicare supplement insurance in Wisconsin, the supplement covers an additional 30 days of skilled care. And it would also cover the skilled care even if you didn't meet that 3-day medical hospitalization criteria. So if you have a Medicare supplement issued through the state of Wisconsin that's subject to Wisconsin law, not all of them are, but a lot of them are, then you get 30 days of skilled coverage also. So it's something to look at. So another source of coverage is long-term care insurance. If you have long-term care insurance, it's time to understand what what the coverage rules are, but that's a paid product. So you've bought that product if you have it. It doesn't come through Medicaid or Medicare. And I have a link here where you can get really good information about long-term care insurance. Now, the rest of the talk is going to be about Medicaid and family care. Davidson. Okay. And so these are talking about the other programs that would provide more comprehensive long-term care coverage in Wisconsin and how you qualify for those programs. So kind of a good time to talk about what have people heard. And if we were in person, I'd be asking people, so what are the kind of things you've heard about Medicaid that are concerning you or that you might want to know about? I've heard that if I need to apply for Medicaid, the state's going to take my home. I have to turn my home over to the state. I've heard that if I need to qualify for Medicaid, the state's going to come and take all my furniture. I've heard that my husband and I can only have $50,000 if we need to qualify for Medicaid in a nursing home. And I've heard a lot of different things. I've heard I can give away $15,000 a year and I can still qualify for Medicaid. Oh, okay. I've heard that too. All right. So these are some of the things that people can, there's no wrong thing people have heard all kinds of crazy things about Medicaid. But I'm not seeing anybody pop up in the chat. So I would talk about, so I'm just kind of filling it in for you. Anybody? Okay. Well, anyway. So we want to talk about the difference in kinds of Medicaid. Hang on. There we go. So the Medicaid that we're talking about today is institutional Medicaid and family care. Okay, I started by the explanation that family care is a kind of Medicaid, but its focus is providing, I've heard you can't have any assets and get Medicaid. Good one. I've heard that a Miller Trust will keep assets from Medicaid. Is this true? You don't need that in Wisconsin. That's the answer to that question. A Miller Trust is not relevant in Wisconsin. So that was probably something you saw online. It's great to Google things online, but before you make decisions, check with somebody, an elder law attorney. So I've heard you can't have any assets and get Medicaid. I'm going to answer that question. That's what a lot of people have heard, but it's not really the way it works. So if you know the system, you're going to see that you can actually keep quite a few assets to qualify for Medicaid. So the two types of Medicaid are institutional Medicaid. And from this point to the end of the proceeding, to the speech, you're going to hear a lot about institutions, institutional, institutionalized, and I apologize. I didn't pick those words. The government did. But those are some of the words that we're talking about. So institutional Medicaid is the kind of Medicaid that will cover people who are in a nursing home. For our purposes, let's talk about people in a nursing home. So if you've been in a nursing home for 30 days or more, institutional Medicaid is a program that would cover. It would also cover if you were in a hospital nursing home and that combination was 30 days or more. So that covers people in a nursing home. Family care is designed to cover people so that they can get care in their community. So if you leave a nursing home, you're not going to be able to use institutional Medicaid. You might be able to use family care to provide for your services. There are lots of other different kinds of Medicaid programs, many different kinds, but these are the two that we're talking about today. So, important thing to understand about the difference between institutional Medicaid and family care is not only sort of the locations where they focus on, but also the nature of the program. And I want to talk a little bit about family care. Family care is a managed care program. So everything is determined based when you qualify for family care. Part of the process is that you're going to choose a managed care organization who's going to really be monitoring your care and responsible for delivering your care. The institutional nursing home Medicaid is more of a sort of a fee for service type situation where any nursing home that takes Medicaid is going to take Medicaid for you if you go there. You don't have to be enrolled in, you know, a certain type of management organization. But the other thing to understand with family care in terms of why it matters to you that it's managed care is that the entity that you're going to be working with if you qualify for family care is only getting a fixed amount of money every month, regardless of whether you need a lot of services or regardless of whether you need just a little bit of services. So in my opinion, anytime we have a managed care system, there is an incentive to regulate the amount of care that's being delivered. And so you need to understand that when we're talking about family care. Another thing is to understand about family care and nursing home care. With family care, your coverage, if you qualify and apply for the program, it really only starts when you are qualified, you've completed the application process, and you've enrolled in the program and chosen your care management entity. So in other words, for families who are dealing with a crisis situation, you may not get all the coverage that you might hope that you could get. Because if you had a crisis and had to put your loved one in a facility, in an assisted living facility, or a crisis and had to get care into the home right away and go through that family care process, you're only going to get payment for the care. The care is going to be covered when you qualify. It's different in a nursing home, and this is something that we're trying to change on the federal level. In a nursing home, if you qualify, you can actually have your benefits go back 3 months if you were otherwise qualified. And this is really helpful in a crisis situation. Let's say mom's got dementia and there was a crisis and was admitted into the nursing home, and the kids are scrambling to get paperwork together to find out if she qualifies and to go through that application process. Meanwhile, mom's bill is racking up in the nursing home, right? Well, if when all is said and done and we get everything together and we get the application filed and it's approved, if mom was qualified, we can go back 3 months to get coverage in the nursing home. We can't do that with family care, and it's one of the main flaws of the program. So that's an important thing to remember. If you're looking for family care, that's only going to be prospective coverage. So it behooves you to get things done very quickly. Another question came up in the chat, and I'm going to address this because it's one of the key things to understand. Is a memory care unit the same as a nursing home? So it's time for a little education on what memory care means. By and large, the term memory care, which probably all of you have heard, is a marketing term. It doesn't mean anything except that the company that's calling their facility memory care is marketing to people with Alzheimer's and dementia. For the most part, most of the memory care facilities are CBRFs. They're community-based residential facility. That's their licensing. So they have to all be licensed to provide care in this state. Highest level of licensing and supervision is a nursing facility. Next level is a community-based residential facility. So most memory care facilities are community-based residential facilities. The amount of regulation, mandatory staffing, and oversight is considerably less in those facilities than it is in a nursing home. Nursing homes have a high level of regulation and oversight. Community-based residential facilities, in my opinion, don't. It's a minimal level that's set by state regulation. So a memory care facility is that type, it's an assisted living facility. It's just marketing to people with memory care. It's probably got a connected hallway, and it's going to charge you 20 to 30% more than the assisted living facility down the road that doesn't say it's memory care. But staffing wise, there's no mandatory difference. So the key to understanding memory care, and this is not to slight memory care providers, okay? It's to make sure that you're educated. So the key to understanding memory care is asking what do they do that they feel qualifies them as memory care? Do they have additional staffing beyond the mandatory minimum? Do they have additional programming and supervision? What are the things that they say make them memory care? Because none of it's required. So you need to understand that. None of it's required. Memory care, marketing term. You need to find out what services are they offering that are over and above normal assisted living or regular assisted living. And sometimes you'll find it's nothing. So sometimes you'll find that memory care was just a label that a facility decided to use for its marketing. Other times there are very good memory care facilities that provide really good care and really focus on that clientele. So it may be significant in that situation, but you can't make an assumption. So, and what you can understand is that in a memory care unit, there are fewer of them in the state that actually participate in the family care program. So it's really important to find out, if you're looking at a particular facility, does that facility participate in the family care program? Okay, so but generally to qualify for, the one thing that's the same about institutional Medicaid and family care is the qualification process financially. Okay, so everything I'm going to say here on in applies whether we're talking nursing home or family care. So the base level to qualify as a single person for family care or nursing home, I call it institutional Medicaid, nursing home Medicaid, is that as a single person, you can have no more than $2,000 in assets. But it's important to remember those are countable assets. So we'll talk about what counts and what doesn't. As a married couple, your resource level is going to be a range, and it's between $50,000 and right now currently $130,000. And that range is based on a calculation that we'll get into, and that is also explained in the spousal impoverishment sheet that I handed out. Because no matter what we get into now, the spousal impoverishment concept is really hard to understand. You need to read it, you need to digest it, and then come back and study it again. So spousal impoverishment for a married couple where only one spouse is either in the nursing home or is applying for family care, that is a range of assets. So it's not just 50, sometimes it's more. Here are the things that don't count. So for a single people or a married couple, one of the most important things that doesn't count is your home. Okay, and here's another tidbit I'm going to tell you. So a home of up to $750,000 in equity is not counted as an asset as long as you either live in the home or intend to return home. And intent is subjective. So for the purpose of qualifying for Medicaid, all that matters is your intent to return home. And even if you, the person who's in the nursing home, for example, are not able to express an intent, your agent could express an intent to return home. So that means if your loved one is going into a nursing home and you are filling out paperwork for Medicaid, or you're filling out paperwork with the billing person who is going to be part of the process, it's important to make sure that you express that intent to return home, especially for a single person. Because they may ask you a question, well, are you going to sell the house? Are you going to go back home? And that's a loaded question. As long as you intend to return home, if you're a single person and you're in the nursing home, you don't have to sell the house to qualify for Medicaid. So one of the biggest pieces of misinformation that people will hear is that they're told they have to sell their house. And this is not so much with married couples, but with us, you know, me putting mom into a nursing home. I'm told by the nursing home social worker that I have to sell mom's house. As long as mom intends to return home, and that's, again, that's subjective. It doesn't mean it's realistic, okay? It's subjective. And who doesn't want to go home, right? As long as mom intends to return home, they cannot count that asset as a resource for Medicaid. So on the other hand, if you followed, for example, the billing person or the admission worker's advice and you sold that house and you had $200,000 in cash from the sale of the house, that's an asset. So the person whose bank account is down to $2,000 and has a house can still qualify for Medicaid. But the person that sold their house and has $2,000 in cash cannot qualify for Medicaid. So that house issue is an important one. That's one of the Easter eggs I want you all to take away. And if you're a married couple, as long as the spouse is living in the home, it's an exempt resource, even if it's worth more than $750,000. Another thing is household equipment and furnishings, personal items are excluded resources. One car of any value is an excluded resource. So if we are talking about how you spend down for Medicaid, it may be the time to replace that 1998 Toyota Corolla, you know, with an updated Toyota Camry, you know, that's nice and new. Then also anything that you have prepaid for your burial or burial trusts and things like that are excluded. Any business property is excluded, but that's a complicated issue we should talk about some other time. And there's more other complicated exclusions. Now that's all for a single person going into the nursing home. So again, one of those things, you do not have to sell your house to qualify for Medicaid if you're a single person. When we're talking about a married couple where it's only one spouse in the nursing home, then we have even more higher protections. So the rules that apply are called spousal impoverishment. And I apologize that I keep looking over my shoulder because I've lost the ability to see the thing on the screen that's ahead of me. So I'm looking behind me, sorry. But the rules that apply are more complicated. And it is based on a range of assets. And the way that we determine the range of assets that you can keep for spousal impoverishment is that we look at the assets that the couple had at a certain point in time, which is called the snapshot date. And so that date is based on a date you entered into a nursing home, or if we're talking about family care, the date that you met functional requirements for the family care program. So the amount of assets you had at that time is added up. And then the general rule is we take half of those assets, and that's what you can keep to qualify for Medicaid. There is a floor to that, and the floor is $50,000. So what that translates in common misinformation that's passed on to people is that you have to spend down to $50,000 to qualify for Medicaid if you're a married couple. That's not always true. It's sometimes true. It's true if the assets you had as a couple on that snapshot date were $80,000. Then half would be 40, but you don't have to spend down to half. You can spend down to 50 and keep 50. But if you had 200,000 on your snapshot date, you don't have to spend down to 50. You only spend down to half, which is 100,000 in that case. So that's a big, big myth. Another big myth about this spend down process is that all the funds have to be spent on care. That's not true either, meaning that spend down can be done a number of different ways, such as home improvements, or trading up on a nicer car, or doing a number of other things. So, so the spend down process is one that can be accomplished a number of different ways. So what's important, and here's the biggest, nobody knows until they've seen one of these programs, is that there are some additional assets that are exempt when we're talking about a married couple. And the biggest one is the retirement funds of the community spouse. So the community spouse is the person who's not needing nursing home care, not applying for family care in the home. So the retirement funds of that spouse are not counted. In other words, if I need to go into a nursing home and my husband has $1 million in his retirement fund, not a single penny of that is counted when I'm applying for Medicaid. Let that sink in so that any of you that may still be working, if your spouse has been diagnosed, you're maximizing the contributions you can be making to your retirement plan as a potential community spouse. So that is a very critical thing for everyone to remember, is that the retirement funds of the community spouse are not counted. And I literally have had couples where the spouse who was not in need of care had over $1 million, and we were able to get his spouse on Medicaid. There's a really good policy reason for it. It's that we don't want people to be impoverishing themselves and spending their retirement funds for Medicaid. But the other important thing to remember is the retirement funds of the spouse that is applying, that is in the nursing home, are counted as assets. So to the extent that as a couple you're making decisions about whose retirement fund are we going to be drawing from, if there's one spouse who's been diagnosed with dementia, it's probably best to start pulling from that fund as much as you can, and the other spouse's fund not as much. Let that sit and let that grow. Okay, so I am going to skip through some of the other slides because this is the problem that I always get into at this point in time. I've given you a couple of the really good Easter eggs, but one of the other things to understand about spousal impoverishment is that once those asset levels are met, there's also the ability for the spouse in the nursing home to transfer income to the spouse in the community. And that's based on a formula as well. So if you are a married couple, you may get a higher amount of assets and also potentially to get some income from the spouse that's in the community. And that's thanks to spousal impoverishment. It's important to do things after a spouse is found eligible, such as putting assets in the name of the community spouse. That's why those powers of attorney need to be really well drafted so that that can be accomplished. And then just one more thing I'll get to, and we will answer questions. Then we'll go to questions. The other myth has to do with divestment. Divestment is something that puts a roadblock to getting Medicaid. And divestment is the idea that if you give away money and then you apply for Medicaid, there is going to be a penalty for the fact that you gave away money. So one of the common myths is, I've heard that I can give away up to $15,000 a year and still qualify for Medicaid. That's not true. $15,000 is a tax rule for when you have to file a tax form. For divestment purposes for Medicaid, they look back when you apply for Medicaid, and if you've given any assets away in the 5 years prior to that, those assets are going to be added up and used to calculate a penalty period. That means for a certain period of time, you don't qualify for Medicaid, even if you meet all the other rules. So that's divestment's a very complicated term, but what I want you to understand is that there is no sort of $15,000 rule that says you can give away money like that and qualify for Medicaid. You can't. There are some exceptions to the rule. So you can transfer money to your spouse. That's completely allowable. That's not considered divestment. You can make a transfer in a situation where you have a child that's been living with you for 2 years in your home. You may be able to put the home in that child's name. Also, you can transfer to a child who has a disability. So those are some of the exceptions, but it's important to understand how that rule could impact your ability to make to qualify for Medicaid. So there's our Mythbuster. Kind of the formula on divestment is that it's the amount you give away is added up, divided by a certain number, and that's the number of days that you don't qualify for Medicaid. Okay, I'm going to go through here. So these are the myths that we've gone over. Here's what I need you to do now is to get this checkup done. Sort of look at the resources that you have in terms of help and support that you can get. And now I think we can ask questions. I see a question in the chat. Are annuities and IRAs considered the retirement funds? So annuities, you can have a retirement fund annuity or you could have a regular annuity. And this is sort of getting into the sort of 301 version of Medicaid qualifying. There are different rules about annuities. So if you're thinking of buying an annuity, please talk to an elder law attorney before you do that, because that could affect your eligibility for Medicaid. Retirement annuities, though, are considered retirement funds, and IRAs, 403Bs, 401Ks, all of those are considered retirement funds that are not counted if they belong to the community spouse. So that's the answer to that question. Any other questions in the chat? And I can stay on a little bit longer too, if that's okay, if people have a question that needs to be answered.
We do have a few questions to be answered. We had some posted a while back that we were kind of just saving up since they didn't necessarily fall into the areas, but I want to make sure for those people that need to leave at 11:30, we can get them out. So I thought we could maybe move on to just how to stay connected, the wrap up, and then we'll go back to any and all the questions if you have time, Carol.
Yes. Okay, that's a good plan. Sorry I was so long-winded.
Well, it's a lot of information that people need to know. We could probably talk all day about it, right, Carol? So
go ahead, Bon.
Yeah, what we plan on doing is we just want to let you guys know how you can stay connected. If Carol, you want to go ahead and advance for me. Thank you. So we have a podcast that Dr. Chin is the host of. It's called Dementia Matters. I'm a little partial to it, but I guess I do work at the research center. We release 2 episodes each month usually, unless we have a special episode, and you can go and listen online. Otherwise, wherever you get your podcasts. And then we do have an e-newsletter from the Alzheimer's Disease Research Center. And in that e-newsletter, we focus on sharing the latest updates about Dementia Matters. And then Jen, if you want to talk briefly about the Alzheimer's Association e-news.
So is that on this slide or?
The next slide.
Carol, can you switch that to the next slide? The Alzheimer's Association has a monthly newsletter that we send out. It's called our e-news, and you can access that by going online. Are you able to switch that to the next slide, Carol?
Yes.
Great. Thanks, Bonnie, for putting that up. So our e-news is at alz.org/e-news. And you can also go to alz.org and find all sorts of other information related to specific dementia diagnoses. We've got information on our website about mild cognitive impairment. We've got information about for folks who have been diagnosed with Alzheimer's disease and other related dementias. And in that part of our website, we've got information on how to continue living your best life. So I want to make sure that you all know that that information is out there as well. And if you go to our website, to our Wisconsin chapter, you'll be able to find on our homepage information about additional education programs and support groups and all of those resources that would be helpful for you as you walk through this journey.
Thanks, Jen. And so I did put the links to the 2 e-newsletters in the chat, and I will send them out afterwards in a follow-up email. The Research Center newsletter comes out monthly, and the Alzheimer's Association e-news comes out weekly. Next slide, please. So then,
Sorry.
That's okay.
I was trying to answer a question in the chat. I'm trying to multitask, which is not a good idea.
It happens. And so we are all very active on social media. So if you are on social media, please feel free to follow us and engage with us that way. You can find us on Facebook, Twitter, or YouTube. You can also find Carol's law practice on Facebook as well if you want to follow her there. Next slide.
Yep, I'm working it.
Oh, you're good. That's a full-time job. And then if you're interested in learning more about our research or becoming a research participant, we have 2 different longitudinal studies on our campus. And if you want to learn more, you can fill out a volunteer form at the link below, and we'll also go ahead and put that in the email I send as a follow-up. And we actually have a special guest joining us today. Rachel is here, and she's going to talk a little bit about a survey that we're looking for people living with MCI to complete. So Rachel, if you'd like to go ahead and talk, we'd appreciate you sharing more about this.
Sure. Hi, everyone. Like Bonnie said, my name is Rachel. I'm a second-year graduate student in the speech language pathology program at UW-Madison. And I'm a part of Dr. Kim Mueller's lab and work closely with Dr. Nathaniel Chin. And we are studying, MCI and dementia and different interventions that we can do. So an area that we've had interest in is what ballroom dance could do to help with cognition in people with MCI. And since we're in COVID times and we can't actually hold a ballroom dance class right now, we're hoping to get some foundational information about people with MCI and their care partners' interest and perceived burden in a potential ballroom dance intervention. So to do that, we have about a 35 to 40 question survey. It takes about 5 to 10 minutes to complete about what your thoughts are on the ballroom dance program, if you're interested in it, what might get in the way of you participating in something like that. So that is kind of what we're doing to see if we can get some foundation to run a dance study later on when COVID is finished. You can take the survey online, or you can take it on paper and send it in the mail. And Bonnie has information about that she'll send out to you once this seminar is completed. And if you do complete the survey, you'll get a $10 Visa gift card from us as a token of our appreciation for completing the survey. So yeah, like I said, Bonnie's got the survey information, the links you can click to take it, the forms that you can use to fill it out, and my contact information will be shared as well. So if you have any questions or concerns, you can contact me too. All right.
Thank you so much, Rachel. We appreciate you coming and sharing about the survey. And I will make sure to put that information in the follow-up email, but does anybody have questions for Rachel right now? If you come up with some, please go ahead and put them in the chat. Otherwise, contact me directly and I can get you the answers or get you to Rachel. So now I think we've, the last thing I want to do before we continue on our Q&A is let you guys know that we do have our next session of Healthy Living with MCI planned for June. And we're going to try doing a Friday morning and see what Friday looks like for trying the program. Normally we do on Saturday, but it is going to be virtual. And so it's going to be June 18th, and it's going to be on diet and what type of foods you should intake. And we have Dr. Michelle Braun joining us as our lead speaker for that presentation. And then in the fall, we don't have the date yet for the fall, but we're going to be going ahead and having one on exercise and physical movement. And then the one in December is going to be on medications and medication interactions, supplements, and vitamins. So
Bonnie, if I could just interrupt for just a second and say, I just wanted to thank Rachel for coming on and introducing the study. For those that are living with MCI and they have the time, I would just ask that you please consider filling out that survey. The study's coming close to an end, and the more responses we get, the better. And for those that think that things like dance could have meaning, that we think the same thing, but we really need to know before we do such an intervention, what are those facilitators and barriers to having people do it. The survey is what will eventually lead to, ideally, the actual intervention study, which our center and Dr. Miller and her team would be leading. So if any of that interests you or you have the time, we would really appreciate you filling that out. And then the second thing, Dr. Michelle Braun is a fantastic speaker as well as a clinical neuropsychologist, and she's written an excellent book called High Octane Brain. So for people who are interested, before that event in June, she's a very well-known presenter and expert on brain health. Yep, thanks.
Thanks so much, Dr. Chin. We appreciate that. So now, if you would like to stay, we'll go ahead and finish up with the Q&A that we weren't able to ask during the allotted time. I will have a survey that I'll be sending out to everyone about today's program. We would greatly appreciate you filling that out. It should only take about 3 to 5 minutes. It's 17, 18 questions. So we can make sure that these programs are what you'd like them to be.